Hello and welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading from UPSC Civil Services Examination Perspective. Today, let us discuss the New Delhi edition of the Hindu newspaper dated 8th August 2023. Now, let's start our discussion with this very important article appearing on page number 6. This news highlights China's worldview with respect to declining global dominance of United States of America and its partners, its postulates, and a reality check for China. Now, this article highlights that the policymakers in China believe that the rule based international order and free market economy, as proposed by the West, is on a decline. And this will be replaced by Chinese promoted world order. Now, Chinese promoted world order or world order as promoted by China is based on three important elements: disorder, asymmetry of power, and fragmentation. And this decline of rule based international order has been proposed by Chinese policymakers, particularly its leader Xi Jinping, as changes unseen in a century. So, Chinese believe in a declining influence of the West and also that of America. Now, the Chinese scholars further believe that the world has entered into the arena of polycentric competition and cooperation. And it is here where China can play a greater role with respect to its global dominance. Now, if you look at this question asked by UPSC in 2021, the question was: the USA is facing an existential threat in the form of China that is much more challenging than the erstwhile Soviet Union. Explain. Now, this question was asked by UPSC not only with respect to the changing geopolitical dynamics of the world order, but also that of India's position. Because as of now, India has inclined more towards the West, particularly America. So, as per China's take on America's global policy, the first point highlighted in this article is that there is loss of global dominance, particularly for the West, that is, United States of America and its allies. And this deterioration in their global dominance has led to their change in policies, as from earlier policy of the West, which was engagement and partial containment, it has now shifted to all out competition with China. And this also includes competition in the Indian Ocean region. And another aspect of competition is direct confrontation with Taiwan. Now, when we talk about confrontation in the Indian Ocean region, it is here where India also gets impacted. And that is why this article becomes very important for us to understand from UPSC GS paper 2 perspective. The third point highlighted in this article is with respect to emerging global partnership. Now, this emerging global partnership is leading to various cooperation and also contestation and confrontation in the international global scenario. Now, this emerging global partnership includes Quad, which includes India, Australia, Japan, and United States of America. I2U2, which includes India, Israel, USA, and UAE, that is United Arab Emirates. Further, there is America, India, Australia trilateral. So, China's take on America's global policies cannot be understood without India's role with respect to this emerging global partnership. And it is in this regard we need to understand the dynamics of India China problem, which particularly caters to the problem of four P's, namely the problem of perception, the problem of perimeter, the problem of power asymmetry, and the problem of emerging partnership in the various corners of the world. Now, when we talk about perception, perimeter, and power asymmetry, then obviously China is considered as a greater power both in terms of military strength and also in terms of its economic strength. And India, on the other hand, is considered a middle power as respect to China. And this difference in economic and military power of China and India has led to various contestation and confrontation. Now, the confrontation between India and China is mainly with respect to the ongoing border issue and China's presence in the Indian Ocean region, which further impacts India's maritime security. China started this concept of string of pearls, and to counter string of pearls, India started the concept of necklace of diamonds. Now, according to the theory of string of pearls, China was to build military and commercial ports to surround India. For example, building a military post in Hambantota port in Sri Lanka, in Indonesia, and India, to counter this strategy and theory of China with respect to string of pearls, India came up with its own theory of necklace of diamonds. So the idea was to go after this string of pearl theory. That is, if China was to build a port in Hambantota, then India is also building a port in Colombo. Now this has further increased the confrontation between India and China. And it is here where the United States of America wants to play a larger role, particularly in the Indian Ocean region. Now, another contentious issue between India and China is with respect to emerging partnership. And here let us understand this concept with respect to growing ties of China with some of the allies of India such as Russia. Now here there are four aspects which needs to be discussed. So when we talk about partnership, on the first hand there is competition in Africa and also in the Central Asian countries. And this competition is particularly with respect to resources and also to counter the Belt and Road Initiative of China. The second concern, particularly for India, is the growing Russia-China axis. Now, although Russia has been an all-weather friend for India, but because of the Ukraine war and India's positioning, the closeness between Russia and China has grown. And this has further impacted by Russia, China and Pakistan trilateral. Now, this further impacts the security aspects for India, as China and Pakistan are all-weather friends. So this also poses the threat of two-front war for India. That is war on the eastern and on the western frontier of the country. Now the third element here is India-US ties in various emerging groups. And these various emerging groups include Quad, America, India, Australia trilateral, I2U2 and also cooperation in the Indian Ocean region. Now one of the major factors for India to enter into these partnership with United States of America is the growing dominance of China in the Indo-Pacific region. Now another concern particularly for India is growing Chinese ties in the West Asia or Middle East. Now the three poles of Middle East around which the geopolitics revolve are Saudi Arabia, Iran and Israel. Now we have a very good relationship with Saudi Arabia, Iran and also Israel. However, China is making big inroad into this particular region, as the Saudi-Iran diplomatic thaw was brokered by China recently. Particularly, China-Iran bonhomie can also be seen through the Quint grouping. And China and Iran has entered into a comprehensive strategic partnership for $400 billion project. Now, although India has a very good relationship with Israel, yet the Israel-Chinese trade is much larger than the India-Israel trade. So this is another concern for India as the trade relations between Israel and China is growing. So overall, this is a complete understanding of India-China problem which can be catered to 4 P's, namely that of perception, perimeter, power asymmetry and partnership. Now this news pertains to page number 6 and 7 and it highlights about superconductivity at room temperature. So according to both these news, a group of physicists in South Korea have reported that they have synthesized a material referred here as LK99 which shows superconductivity at room temperature. Now theoretically this is not possible because the properties of superconductor are exhibited when a material is cooled to temperatures towards 0 Kelvin or very low temperature. So superconductivity can be achieved at very low temperature and at very high pressure. So the requirement is low temperature or extremely low temperature and very high pressure. But here a research from South Korean University has highlighted that they have synthesized a material LK99 showing superconductivity properties at room temperature. Now this aspect defies the scientific logic, and because of this, independent verification of this superconductivity at room temperature is necessary for such an important technological breakthrough. Now as I've already stated that superconductivity takes place at low temperature or extremely low temperature which is close to 0 degree Kelvin and at very high pressure. So certain materials when cooled to a very low temperature of 0 degree Kelvin, then they show the properties of superconductivity. Now to achieve such temperature, it is very difficult in normal circumstances. and hence it's not easy to achieve superconductivity for certain materials. 0 Kelvin is equivalent to minus 273 degrees Celsius. Now another important property of superconductor is with respect to flow of current. Now in our school we have studied about Ohm's law, which is regarding measure of resistance during flow of current. Now if current flows from say point A to point B, then there would be resistance in the flow of current, and this resistance is measured in the form of ohm. So it says that a basic law regarding flow of currents was discovered by G.S. Ohm in 1828, long before the physical mechanism responsible for flow of currents was discovered. So he highlighted that imagine a conductor through which current I is flowing, and let V be the potential difference between the ends of the conductor. And accordingly, Ohm's law states that V is directly proportional to I, or V is equal to R into I. Now here R is the constant of proportionality called the resistance. So when current flows from one end to another end, there is resistance. But when we are talking about superconductors, there is zero resistance during flow of current. So this is one of the very important property of superconductor, as there is zero resistance, and hence such materials conduct direct current without any loss of energy when cooled below a certain temperature, or called critical temperature. That is the temperature below which that material shows the properties of superconductivity. Now such materials also show magnetic properties as they transition to superconducting state. Now mercury was the first element to become superconductor below 4 degree Kelvin. Now so far semiconductors are used in the particle accelerators, it is used in the nuclear fusion devices, it is used in the MRI machines, it is also used in the maglev trains because of its magnetic properties. Now another important property or aspect with respect to superconductivity is that when a superconductor is cooled under the critical temperature, then it does not permit the magnetic field to go through it. So the magnetic field are expelled if a superconductor is placed here. So if a magnetic field is going like this and a superconductor is placed here, then the magnetic field will deviate. That is, it will not go in a straight line. And this aspect of deviation or expelling of magnetic field is known as the Meissner effect. Now the news on page number 7 highlights about two important charts. And here it mentions about a compound referred as LaH10. Now this LaH10 compound, although shows superconductivity at 250 degree Kelvin, yet for this purpose a very high pressure is required. So the point here is that so far superconductivity has not been achieved at room temperature and pressure. So if the scientist in South Korea is claiming that they have achieved superconductivity for LK99 at room temperature and pressure, then such a claim must be verified independently by scientific experts around the world, because this is a very important scientific breakthrough, as there are number of applications for superconductivity. For example, transmission of electricity, particularly for heavy industrial applications, as in such cases then there would be zero resistance for transfer of electricity through these superconductors. So this technology is very important, and if someone has achieved this technology, then it must be verified by independent scientists around the world. Now this topic of superconductor become very important from the perspective of prelims and also mains examination under GS paper 3 with respect to science and technology. Now let's take up this news appearing on page number 1. Now this talks about the contentious bill which was passed yesterday by Rajya Sabha, and the bill is Government of National Capital Territory of Delhi Amendment Bill 2023, and this bill amends the Government of National Capital Territory of Delhi Act 1991. Now this bill is with respect to control over the services under the Delhi government. So effectively we can say that this dilutes the power of the government of Delhi over control over services. Now control over services also includes transfer and posting of officers. So here this news highlights that as Rajya Sabha passes Delhi Services Bill, Union Home Minister sharpens attack on the Chief Minister of Delhi. Now this topic is very important from the examination perspective, under GS paper 2 with respect to legislation and also center state relationship, and particularly Article 239AA of the Indian Constitution, which was added by the Constitution 69th Amendment. Now, this Constitution 69th Amendment, which was added on the recommendation of Balakrishnan Committee, provides a special arrangement with respect to Delhi. So, Delhi, although being a union territory, or it has been given a provision whereby the people of Delhi, through direct election, can elect their own government. So, this article highlights that as from the date of commencement of the Constitution 69th Amendment Act 1991, the Union Territory of Delhi shall be called the National Capital Territory of Delhi, and the administrator thereof, appointed under Article 239 of the Indian Constitution, shall be designated as the Lieutenant Governor of Delhi. Now, when we are talking about Delhi, there are few things which you should know. Now, Delhi, although being a union territory, it has its own elected government. So, an elected government can frame laws as provided under the state list, which has been provided under 7th schedule of the Indian Constitution. However, there are certain exceptions. So, according to Article 239AA Clause 3 Subclause A, it highlights that the government of Delhi under state list cannot legislate on entry 1 of state list with respect to public order. It cannot legislate on entry 2 of state list, which is with respect to police, and under entry 18 of state list, that is under which provides for land. So the Delhi government under state list cannot make laws with respect to public order, police and land. And other than this, it can make laws on any entry under state list and also concurrent list, which is list 3. Now, an interesting point to be noted here is that entry 41 of second list, that is state list, provides for state public services and state public service commission. So effectively, this amendment introduced by the central government impacts entry 41 of the state list. And according to the constitutional provision under Article 239AA, there is no bar or there is no prohibition with respect to making laws under entry 41 by Delhi government. And this aspect was also highlighted by the Supreme Court judgment recently. So, in the case of Government of National Capital Territory of Delhi versus Union of India, apart from other things, the Supreme Court also focused on entry 41 of state list, and it highlighted that National Capital Territory of Delhi has legislative and executive power over services, which has been provided under entry 41 of this list 2 of the 7th schedule. So according to the Constitution of India, under Article 239AA, the state government of Delhi cannot legislate on matters pertaining to public order, police and land. However, no such restriction appears with respect to entry 41 of state list for Delhi government. And it is here where this bill becomes contentious. And this is exactly what was debated yesterday in the Rajya Sabha, as it was highlighted that this bill goes against Supreme Court judgment, whereby the Supreme Court in its judgment had also highlighted that Delhi government has control over administration and control of civil servants in Delhi. Now, the Supreme Court judgment becomes important because UPSC has directly asked question on Supreme Court judgment and also on Constitution 69th Amendment. So, the question asked in 2016 was, discuss the essentials of the 69th Constitutional Amendment Act and anomalies, if any, that have led to recent reported conflicts between the elected representatives and the institution of Lieutenant Governor in the administration of Delhi. Do you think that this will give rise to a new trend in the functioning of Indian federal politics? Now, the question asked in 2018, particularly after the Supreme Court judgment, was that whether the Supreme Court judgment of July 2018 can settle the political tussle between the Lieutenant Governor and elected government of Delhi. Examine. This question carried 15 marks and the question asked in 2016 carried 12.5 marks. So as you can see that this topic with respect to Delhi and its contentious relation with the central government, particularly with respect to Constitution 69th Amendment, becomes very important from the perspective of civil services examination. So after understanding this backdrop and an important highlight of the Supreme Court judgment, let's understand some of the important highlights of this particular amendment which was introduced yesterday. And the amendment has also changed certain aspect which was introduced through an ordinance few months earlier. So let's go through the important highlights of the Government of National Capital Territory of Delhi Amendment Act of 2023. So the first point highlighted here is that it provides for or constitutes a National Capital Civil Services Authority which will take decisions pertaining to the posting and control of civil servants posted in Delhi. Now this authority comprises of 3 members headed by the Chief Minister of Delhi, comprises of Chief Secretary of Delhi government and also comprises of Principal Secretary functioning under the Union Home Ministry. Now the overall functioning of this authority would be to make recommendations to the Lieutenant Governor of Delhi with respect to transfer, postings and also to conduct disciplinary inquiry against all Group A officers and officers of DANIX serving under Delhi government. Now DANIX means Delhi, Andaman and Nicobar, Lakshadweep, Daman and Diu and Dadra and Nagar Haveli Civil Services. However, the recommendation of the committee with respect to transfer, posting or disciplinary action will not impact those officers who handles matters pertaining to police, law and order and land because these directly come under the purview of central government. Another important aspect highlighted in the amendment is that the decision of LG shall be final and in case of difference of opinion, the decision of LG shall prevail. Coming to the third point, it talks about appointments, particularly of statutory commissions and tribunals in Delhi. Now here certain changes have been made with respect to the previous ordinance. Now generally, the members are to be constituted, appointed or nominated by the President. However, for those bodies created under the parliamentary law, for such bodies, members are to be appointed by the President of India. Whereas for those bodies, that is those statutory commissions or tribunals constituted under the government of Delhi, then the National Capital Civil Service Authority shall recommend a panel of names to be appointed by the Lieutenant Governor of Delhi. So this is a change as compared to the previous ordinance introduced by the central government. Now other than this, let's also go through some of the important highlights of the Supreme Court judgment in the case of Government of National Capital Territory of Delhi versus Union of India. Now here the Supreme Court highlighted that there does not exist a homogeneous class of union territories with similar governance structures. The court highlighted that the Delhi government is not similar to other union territories by virtue of Article 239AA. The National Capital Territory of Delhi is accorded a sui generis status, which sets it apart from other union territories. It further says that the Legislative Assembly of Delhi has competence over entries in List 2 and List 3, except for the expressly excluded entries in List 2, that is, law and order, police, and land. It further says that in addition to entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to National Capital Territory of Delhi, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA3 Clause A. So it mentions a very important point that Parliament has legislative competence over all matters in List 2. Now all matters here also includes entry 41. It further says that the executive power of Delhi is co-extensive with its legislative power, which means that it shall extend to all matters with respect to which it has power to legislate. So it also means that if Delhi government has power to legislate over services under entry 41 in the state list, then the Delhi government also has executive power with respect to appointment and transfers. Another important aspect is that the Union of India has executive power only over the 3 entries in List 2, namely law and order, police and land, over which National Capital Territory of Delhi does not have legislative competence. It further says that executive power of National Capital Territory of Delhi with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon by the Union by the Constitution or by a law enacted by Parliament. So in other words, it also means that Parliament may by law make provisions for other aspects pertaining to Delhi under List 2 and List 3. Now to understand this aspect, let us again go through Article 239AA Clause 3. So it highlights that subject to the provision of this constitution, the legislative assembly shall have power to make laws for the whole or any part of national capital territory with respect to any of the matters enumerated in the state list or in the concurrent list, in so far as any such matter is applicable to the union territories, except matters with respect to entries 1, 2 and 18 of state list. Now, this phrase, insofar as, has been further explained by the Supreme Court. And the Supreme Court in this regard highlights that this phrase, insofar as any such matter is applicable to the Union Territory, cannot be read to further exclude the legislative power of Delhi over entries in the state list or concurrent list, over and above those subjects which have been expressly excluded. In other words, other than those three entries on law and order, police, and land, the National Capital Territory of Delhi is empowered to legislate on all other entries, including entry 41, which pertains to services. So these are some of the important highlights of the Supreme Court decision of May 2023 with respect to Government of NCT of Delhi versus Union of India. So here we need to understand the basics with respect to Delhi, the changes which this bill intends to achieve, and also the constitutional deadlock, particularly with respect to entry 41 of the state list. As questions have been asked in the past with respect to Supreme Court judgment, so questions can also be asked in the future with respect to either to critically analyze the Supreme Court judgment or to critically analyze this particular amendment as introduced by the central government yesterday. And this topic becomes a very important topic from the perspective of GS paper 2. Now let's take up this article appearing on page number 6. And this article highlights that neither the right to privacy nor the right to information. Now there are three important aspects to be understood in this particular article. The first aspect is that the author highlights data collection in India is not forbidden by law and hence is not covered under the Digital Personal Data Protection Bill 2023. So the author says that the problem is with respect to data collection and not data protection. The second point highlighted by the author is that the data of citizens are more transparent for the government and also for private entities. However, the reverse is not true, which means that if a citizen intends to ask for certain data or information from the government, then it becomes rather difficult to obtain such data. And it is in this regard where we talk about the Right to Information Act. And the third aspect is with respect to Section 81J of RTI Act of 2005. So let us understand these three aspects from the perspective of Digital Personal Data Protection Bill 2023. Now this bill has been introduced in the Parliament and it says that it provides for processing of digital personal data in a manner that recognizes both the right of individuals and also to protect their personal data and need to process such personal data for lawful purposes and for matters connected therewith. So data can be collected for processing for lawful purpose. So it's important to understand that what is lawful here. And the bill under section 4 expressly mentions that for the purpose of this section, which deals with ground for processing of personal data, it says that the expression lawful purpose means any purpose which is not expressly forbidden by law. Now it's important to understand the term personal data, which says that personal data means any data about an individual who is identifiable by or in relation to such data. So it has not specifically provided for that what constitutes personal data, but any data through which an individual can be identified. Could be his name, his phone number, his address, or their Aadhaar number, can be anything. And the term person includes an individual, a Hindu undivided family, a company, a firm, an association of persons or body of individuals, whether incorporated or not, the state, and every artificial juristic person not falling within any of the preceding subclauses, which means that which is separate from these terms mentioned here. Now let us understand this concept of lawful purpose with respect to anything which is not expressly forbidden by law. Suppose there are certain activities which are particularly or specifically forbidden by law. then such activity or data collected for such activity will be restricted. However, there are certain activities which is not forbidden by law, yet it impacts the rights of citizens. That is, such things which is not particularly forbidden by any legislation or any law, yet it impacts the rights of citizens. For example, someone extracting details such as names, address, phone number of beneficiaries from government portal. Now, technically speaking, this is not forbidden by law because this is not a crime or this is not an offense under any particular legislation. So, the real problem, as highlighted by the author, is the problem of data collection and not data protection, because the author highlights that collection of data, even from government portal, such as details of pension holders or details of MG Narega workers or any other details. So such data collection is not forbidden by law and hence not an offense, which can be punished under any specific legislation. Now coming to the second aspect of our discussion, whereby we highlighted that it is more easier for the government or private entities to have data of citizens, which means that to avail data of citizens for government or private entities, it is more transparent but not otherwise. Now this can be understood by understanding certain terms and also section 36 of the Data Protection Bill 2023. Now before understanding section 36, let's look into some of the important terms. Now these terms are data fiduciary. So it says that data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. So this data fiduciary is any individual or any person, which can be an organization, who alone or in conjunction of other persons determines the purpose and means of processing of personal data. Now, data principal means the individual to whom the personal data relates. So, data principal is such individual whose data is to be processed or whose data it relates, and where such individual is a child, then in such case includes parents or lawful guardian of such a child. And if it is a person with disability, then it includes her lawful guardian acting on her behalf. So basically, data principal is any individual, including child or person with disability, whose data is to be processed by data fiduciary. So after understanding the concept of data principal and data fiduciary, let's look into section 36. So section 36 highlights that the central government may, for the purposes of this act, require the board, that is the Data Protection Board of India, and any data fiduciary or intermediary to furnish such information as it may call for. So any information which is being processed by the data fiduciary can be called upon by the central government. That is, the central government can ask for any of such data which is processed by a data fiduciary. So it is in this sense, this article highlights that for the government, it becomes very easy to obtain our data. That is, our data is very transparent for the government. But the reverse is not true. Now after this, let's understand the third aspect of our discussion with respect to section 8(1)(j) of RTI Act. Now section 8 of RTI Act provides for grounds on which information cannot be disclosed. So it says that exemption from disclosure of information. And in this regard, section 8(1)(j) says that personal information of an individual shall not be disclosed if such information has no relationship with public activity or interest. That is, such personal information shall not be disclosed if there is no connection of such personal information of any public activity or any public interest, or such personal information shall not be disclosed which cause unwarranted invasion of privacy of individuals. So those personal information shall not be disclosed as per section 8(1)(j) of RTI Act. Now these personal information can only be disclosed if the authority, that is the Central Public Information Officer, State Public Information Officer, or the appellate authority is satisfied that disclosure of such personal information of any individual satisfies larger public interest or it justifies the disclosure of information either for public interest or with respect to any public activity. So, unless there is any public interest or public activity involved, personal information of an individual shall not be disclosed according to section 81J of RTI Act. Now, the Personal Data Protection Bill of 2023 intends to amend this particular provision of RTI Act. And accordingly, it highlights that in section 8 of RTI Act 2005, in subsection 1 for clause J, the following shall be substituted, which means that all these barriers which has been placed with respect to disclosure of personal information has been done away with, as the amended provision highlights that information which relates to personal information. So the aspects of privacy or public activity or public interest has been done away with. So this is another concern which has been highlighted in this article. Now another concern highlighted in this article is that the officers of the Data Protection Board shall be appointed by the central government. So ultimately there would be no check and balance, as they would be officers of the central government and they would have to abide the orders given by the central government. So these are some of the concerns expressed in this article with respect to the Digital Personal Data Protection Bill of 2023 and also its correlation with section 81J of RTI Act. Now this topic becomes important from the perspective of GS paper 2, particularly rights issue and also the aspect of legislation. Now the important highlights of the Digital Personal Data Protection Bill 2023 has been provided in the PDF. So you can go through the important highlights and also certain concerns. So with this, we come to an end to today's analysis. Thank you for watching DNS.